Hello, everyone, and welcome to Uncivil Law. For today's case, we have a case out of the Third Circuit Court of Appeals coming out of Pennsylvania. This is Greater Philadelphia Chamber of Commerce versus City of Philadelphia. In this case, the City of Philadelphia passed a rule that prohibited employers from asking for past salary as part of an employment negotiation or hiring practice. So when they were doing hiring, they couldn't ask how much you made at your prior jobs. The issue here is whether or not this is constitutional or whether or not it is an improper restriction of free speech. So we're going to get into the case and the analysis. So let's get started with this. This appeal requires us to decide whether a Philadelphia ordinance that prohibits employers from inquiring into prospective employee wage history in setting or negotiating that employee wage violates the First Amendment. So all you guys in chat, you can't ask me how much I've gotten before in super chats before as part of deciding how much you are going to give as super chats, because that would be asking my prior wage history. So, take note. The district court held the ordinance unconstitutional insofar as it prohibits the inquiry. However, the court upheld the provision of the ordinance that prohibits reliance on wage history based on the court's conclusion that such reliance did not implicate protected speech. For the reasons below, we affirm that court insofar as it upholds the reliance, but reverse it insofar as it strikes down the inquiry. So the Court of Appeals is saying that, as to the district court saying you're not allowed to use that factor in your employment negotiations, that part was ruled to be constitutional by the district court. So the district court said, yeah, you can't use it as part of the negotiation, but you can ask about it. So the Court of Appeals is saying, well, you can't rely on it and you can't ask. So you can't even ask that at all. So that's the decision here. In 2017, the City of Philadelphia enacted an ordinance to address the disparity in the pay and women and minorities, as often called the pay gap. Whether or not the pay gap actually exists when you account for all the relevant factors is, of course, controversial. And then you'd have to get into why it exists. So to the extent it does exist, why? And what are those reasons and rationales? So, yeah. The ordinance contains two provisions: the inquiry provision, which prohibits an employer from asking, and a reliance provision, which prohibits an employer from relying on wage history at any point in the process of setting or negotiating a prospective employee's wage. The Greater Philadelphia Chamber of Commerce filed the suit individually and on behalf of some of its members, alleging that both provisions of the ordinance infringe on the freedom of speech of the Chamber and its members. The Chamber concedes that the pay gap exists, and the city has substantial governing interest in addressing it. However, the Chamber argues that the city passed the ordinance with only the barest of legislative records and therefore did not present sufficient evidence to establish that the ordinance would satisfy the city's objective. Accordingly, the Chamber claims the ordinance cannot survive its First Amendment challenge under either strict or intermediate scrutiny. The district court agreed that the inquiry provision violated the First Amendment speech rights and invalidated that part, but the court concluded the reliance provision withstood the First Amendment challenge because it did not impact speech. As we explained below, we conclude the district court erred in holding that the inquiry provision was unconstitutional. We believe the court's analysis of that provision applied a much higher standard than required. The Supreme Court has not demanded that an enacting authority achieve legislative certainty or produce empirical proof that adopted legislation would achieve the stated interest even when applying strict scrutiny. Rather, the appropriate inquiry requires courts to determine whether the legislature has drawn reasonable inferences based on substantial evidence. The Supreme Court has even permitted litigants to justify speech restrictions by reference to studies and anecdotes pertaining to different localities altogether, or even, in a case applying strict scrutiny, to justify restrictions based solely on history, consensus, and simple common sense. In short, the Supreme Court has upheld similar restrictions based on much less evidence than is presented here. So yes, we're in sort of a freedom of speech analysis, as you would well expect. And we have to decide what level of scrutiny applies, and we have to decide whether the restrictions are proper. And they're pointing out that the Supreme Court has, on occasion, said that various kinds of restrictions are proper under either intermediate scrutiny, which typically applies to commercial speech, or even strict scrutiny, which applies to most other kinds of speech, particularly as it relates to subject matter. And they're saying that this case that we have here is parallel to that. Now, the distinction, the degree to which it is parallel is, of course, an issue that is debatable. Every analogy fails eventually. Every analogy ultimately does not work. So how analogous is it to those other cases is debatable, but the Third Circuit Court of Appeals feels it's analogous enough to allow this ordinance to go forward. So let's read a little bit more. Gifts in general are not tax deductible. If you were making a donation to a charity, that'd be tax deductible, but gifts to just normally are not tax deductible. So you couldn't deduct the gift even if I did nothing with it. In fact, I think in some instances the person giving the gift has to pay taxes on it rather than the gift giver. But I'm not an expert on tax law, so. As we noted at the outset, the district court granted the Chamber's motion for preliminary injunction as to the inquiry provision. The court held it likely violated the Chamber and members' free speech rights. However, it found that the reliance provision, which prohibits relying on an applicant's wage history at any point in the part of the process, regulates conduct rather than speech. And fair enough as to the reliance interest. At that point, you're not asking anyone to express anything. You're not asking words to be used. You're only asking what you can and cannot do. So saying, you can't use this information as part of your negotiations, that's not a freedom of speech issue because no one is speaking. So that makes sense from the district court. The court found the inquiry provision did implicate speech and that it could not survive even the less stringent intermediate scrutiny required under the First Amendment, which is typically used for commercial type speech, especially advertisements. Thus, the court did not discuss the actual level of scrutiny required to withstand the Chamber's First Amendment challenge, which kind of makes sense because if you're saying it doesn't even pass intermediate scrutiny, there's no reason to decide if you need intermediate scrutiny or strict scrutiny, right? If it doesn't pass the lower threshold, then it doesn't pass the upper threshold by definition. Rather, the court held the ordinance was unconstitutional under the less stringent standard of Central Hudson. That decision rested on the court's belief that the city had not presented substantial evidence to support a conclusion that the inquiry provision would help close the wage gap. This appeal and cross-appeal followed. The Chamber argues the district court erred in refusing to enjoin the reliance provision and that both provisions should be reviewed under strict scrutiny. The city alleges the district court erred in enjoining the inquiry process. As discussed above, the inquiry provision of the ordinance prohibits asking a job applicant in writing or otherwise about the applicant's wage history, requiring disclosure of wage history, or conditioning employment or consideration for an interview or employment on disclosure of wage history. Unlike the reliance provision, the inquiry provision clearly regulates speech because it prevents employers from asking potential applicants specific questions. The district court was therefore correct in concluding it was first necessary to determine the appropriate levels of scrutiny to apply to the provision. The city argues that speech at issue is commercial speech and therefore intermediate scrutiny under the test outlined in Central Hudson is appropriate. The Chamber argues that even if such speech is commercial speech, we should apply strict scrutiny because the inquiry provision restricts expression based on the content and the speaker. We agree with the district court that the inquiry provision regulates commercial speech and that intermediate scrutiny under Central Hudson is the appropriate level of review. And I would tend to agree with that decision. This does seem to be pretty commercial speech. It is speech only used for the purpose of negotiating a particular employment contract, which is commercial in nature. It's not expressing, it's only asking for expression of facts, not even opinion. So it does seem to fall within the scope of commercial speech. So it seems to fall within intermediate scrutiny. That seems correct. The Supreme Court has described commercial speech as expression related solely to the economic interests of the speaker and its audience. More importantly, even if we were to credit the Chamber's suggestion, we would nevertheless not be free to ignore the Supreme Court's decision in the case of Florida Bar, where the court considered and rejected a similar overbreadth argument. The respondents in Florida Bar argued that the ban on communications to all accident victims within 30 days of an accident was overbroad because it did not distinguish between those whom the provision was aiming to protect, injury victims who were vulnerable, and those accident victims who are ready, willing, and able to utilize a lawyer's services. Rather than require the Bar Association to draw difficult lines, the court concluded that the blanket ban applicable to all post-accident or disaster solicitations for a brief 30 days was narrowly tailored. So lawyers doing direct advertising to people who are victims of crashes by direct calling or direct solicitation, poses some concern, and it poses that they might be particularly vulnerable. We're concerned about the ambulance chasers. So what we're going to do here is we're going to say, look, you cannot engage in a direct advertisement to someone who is the victim of an accident within 30 days. Give them some time to recover, some time to be able to deal with this. But, and the Florida Bar said, well, and the Florida Bar is the private organization of lawyers, not the regulation authority. So the Florida Bar in this case is a private entity collection of lawyers. Most states have this. And it said, our members want to be able to do this, and it doesn't attempt to distinguish those who are vulnerable from those who are not vulnerable. And the Supreme Court said, yeah, well, rather than trying to line draw this, we're just going to say it's okay to have the broad policy. So that makes sense, and also makes sense in this context. It might not be a problem for some employees to be disclosing it. Some employees might be very fierce negotiators. But we're not going to attempt to line draw that. We're just going to have a blanket policy so we don't have to get into that weeds. So kind of similar in that respect, it seems correct. Thus, even if we were to credit the Chamber's argument the law is overbroad, it would not prevent the inquiry provision from surviving intermediate scrutiny. The Supreme Court has refused to invalidate restrictions on commercial speech that go only marginally beyond what would adequately have served the government interest. We have no trouble concluding that the city has demonstrated a proportionate fit between its substantial interest and the legislative attempt to advance that interest. For the foregoing reasons, we affirm the District Court's denial of the preliminary injunction as to the reliance provision, and we vacate the District Court's grant of preliminary injunction as to the inquiry provision, and remand with directions to the District Court to deny the preliminary injunction as to the inquiry provision. So that is the case of the Greater Philadelphia Chamber of Commerce versus the City of Philadelphia. In this case, we learned that the City of Philadelphia put in a regulation that prohibits employers in the city from either asking for past wage information or from using that information to set salaries. And the District Court said the reliance interest was constitutional, but the asking was unconstitutional because it went to speech. In this decision from the Third Circuit Court of Appeals, they said, no, this is intermediate scrutiny because it's commercial speech. It's commercial speech because it relates only to the financial interests of the people negotiating this contract. It's just a straight line contract, straight line negotiation, service for price, and therefore it is just regulation of commercial speech. So intermediate scrutiny should be the rule. And in that, it passes because they said that they had enough evidence that there was a problem of this wage gap, and therefore they could regulate against that. And that is the end of this case. Thank you for joining me as we both read this case together and now better understand the law. If you're enjoying this legal education content, please subscribe to this channel. It really helps us grow. And check out one of our other videos, including the one that's currently being displayed on the thumbnail on screen. Thank you so much for your continued support. And until later, my friends, cheers and goodbye.